Welcome everybody to the first webinar in Conn Maciel Carey's OSHA webinar series 2016. We completed the 2015 series with, I think we did about 8 or 9 different webinars last year. Great audience participation, a lot of great interaction with everybody after those events. So we are pleased to be able to do that again this year, and we are launching the 2016 series today with something that's becoming a annual tradition, such as it is for a law firm that has existed for 1 year. These are the beginnings of traditions, and this tradition will be in January every year. Hopefully we'll be doing a webinar where we look back at the previous year and what we learned from OSHA, from new regulations, new trends in enforcement, other significant events and developments that might tell us or inform us what to expect going forward, and then to take our best guess for a forecast for what to expect or important issues and developments to track for 2016 or for the next year coming up. And one of the nice things, if any of you all participated in our first annual OSHA Update webinar in January 2015, you might see some repeat slides when we do our look back at 2015 as an indication of what good prognosticators we are, and how our identifying what was going to be key issues in 2015 were in fact significant issues in 2015, and hopefully I won't mention that in 2017 if we got it all wrong in 2016, but this is where we are. So let me tell you a little bit about the faceless voices you're going to hear today. I know most of you on the line here. My name is Eric Conn. I'm one of the founding partners of Conn Maciel Carey and chair of the firm's National OSHA Workplace Safety Practice Group. Personally, my practice is focused exclusively on OSHA and workplace safety issues for the last 15 years. I practiced for more than a decade alongside the first general counsel of the OSHA Review Commission, and since then have worked with employers and trade associations to help manage inspections, investigations, rulemaking activities, and most often litigation against the government to address flawed citations, and they're always flawed citations. I'll be joined today by the majority of the folks in our OSHA team, our deep bench of OSHA specialist attorneys here at Conn Maciel Carey. I'll let everybody introduce themselves a little bit when it comes their time to speak, but we will be joined today by my partners Kate McMahon and Amanda Walker, and 2 of our OSHA associates, Lindsay Smith and Dan Deacon. We did have our California partner, Andrew Summer, who does a lot of Cal OSHA work, West Coast OSHA work, was supposed to join us today but has been called out in an emergency. So I'm going to fill in on some of the topics that he was going to cover. But we do have the majority of our group with us today, and we're so excited that so many of you could join us. And we look forward to an exciting webinar topic today, but also with the whole series. And we look forward to your input about that. Just want to do a quick check here because we are experimenting with a new computer microphone today. Wanted to see if anybody was having trouble with audio, and make sure that everybody's hearing us okay and that we're ready to go. So if you're having trouble, just let me know. All right, I'm seeing a lot of sounds fine, sounds good. All right, so let's dig in. What are we going to be talking about today? This is the big reveal. What are these top 5 issues that we think are going to be big in 2016? First, we're going to start off with a review of 2015, enforcement data and trends, and some sort of breaking stories in the OSHA world from 2015, because in my experience, past is prologue. Things that were important in 2015 will either continue to be important in 2016 or will inform those that will become important in 2016. And then we'll talk about what we think are the top 5 OSHA developments to track in 2016. And those are a striking and very unexpected new civil penalty authority that OSHA has been given by Congress. What are the major rulemaking activities that we can expect, particularly the rules that we think may actually get done and become the law before the end of the Obama administration. We'll talk about some developments in the context of criminal prosecutions for worker safety violations and why those prosecutions and investigations are on the rise, and we expect that to continue. And then finally, a couple other things. We'll be talking about a FAR and Department of Labor blacklisting rule. This is not technically an OSHA rule, but it will have significant ramifications for OSHA and how you need to handle your OSHA record and citations from OSHA. And then finally, a topic that has been sort of on our most important items to track and to follow for the last several years has been the development and the rollout of OSHA's new globally harmonized standard, GHS version of U.S. Hazard Communication Standard. We're coming into the sort of final year of the rollout of that standard, so we'll talk to you about what to expect on that front. So I'm going to lead the discussion about the 2015 year in review and start off with, as I've done the last couple of years, reviewing some of the inspection and enforcement data. Some of it is illuminating, some of it is not, but we always sort of cover this data, and I know people are interested to see it. So what we saw from a total number of OSHA inspections was, for the third year in a row, a lower number of total inspections. And what's interesting about that is that in 2013, and this is fiscal year, and OSHA's fiscal year is October 1 through September 30th every year. 2013 and 2014 numbers dipped from what had been sort of record levels of numbers of inspections. Dipped in 13 and 14, but we were told by folks at OSHA that was a result of the government shutdown and the sequestration activity in those years. So that really affected, OSHA sort of grinding to a halt and starting back up again had a pretty meaningful impact on the number of inspections they conducted. This year, I was a little surprised to see the lower numbers, but through discussions with my colleagues, I was reminded of OSHA's new inspection weighting system, where OSHA has made a commitment to do more important inspections, more in-depth inspections, more focused inspections on complex hazards, which as a necessary result would mean fewer inspections but more meaningful inspections. And so they actually said, I remember when they announced the weighting system, that OSHA was going to no longer track the number of inspections that they did because they wanted to get away from this almost quota feeling among their inspectors and among their area and regional offices as to an expectation of number of inspections. But they did track it for fiscal year 2015, and here's what it looked like. And as they indicated, the number of inspections has gone down, even with a full year, without a threat of a government shutdown or an actual government shutdown. Still fewer inspections, even than at the tail end of the Bush administration. But what we did see was that the man hours per inspection did go up considerably, so these are more in-depth inspections. We also saw a slightly smaller number of total violations issued, which would not be unexpected if the number of inspections was down, but this is what that data looked like. One really interesting development here in 2015, fiscal year 2015, was that the average penalty per serious violation went up a considerable amount. And I remember the very beginning of the Obama administration, OSHA talked about a goal, this was an expressed goal, of tripling the size of the average per serious violation penalty. And at the end of the Bush administration, that was less than $1,000 per serious violation. OSHA got that number, basically doubled that number and plateaued. But in fiscal year 2015, we saw that number go up over $3,000, so they accomplished their goal of tripling the average per serious violation. So, one of the ways that I believe they accomplished this was, again, by the weighting system for inspections, that they got involved in more complex inspections, more significant inspections, more in-depth inspections, and with those were able to find, I guess, what they would consider in their, in the way they calculate their penalties to be, higher probability or higher significance, higher consequence types of violations, which as a natural following through naturally their calculation system, they were able to issue higher penalties. My colleague Lindsay Smith will be talking about a gift that Congress handed to OSHA at the end of the year, a nice Christmas gift to OSHA that is going to sort of completely change the landscape, and this number is going to be unrecognizable, is our expectation in 2016 and going forward with some new civil penalty authority that was granted. Another statistic here, not breaking news by any stretch, but one of the most important statistics, I think, when evaluating OSHA enforcement, and that is the percent of in-compliance inspections, meaning inspections conducted by OSHA where no citations are issued. And this shows you that year after year after year after year, it is very, very difficult to get through an OSHA inspection without at least one serious violation being issued. 75% of the time, OSHA finds something. And I don't think that's because 75% of our workplaces in this country are breaking the law. I think it's part of the mentality that I have heard from inspectors out in the field that, hey, I've got to find something to prove to my boss that I was here. If they get in the door, they're going to find something. So it's a very good reason to try and keep them out of the door. Avoid employee complaints with a robust safety program and systems and programs in place for your employees to bring their concerns to you internally rather than having to go out to OSHA to get relief or to get change in the workplace. And then obviously robust programs to avoid incidents, accidents, injuries, the other big triggers for OSHA inspections. Another trend, if anybody on this call who's talked to me about OSHA in the last 5 or 6 years has heard me harp on this issue, once again, the percentage of repeat violations issued by OSHA has gone up. This is the one data point that is consistently on the rise every year from OSHA. Year after year after year, the number of serious violations stays in the same general bandwidth. The number of willful violations stays in the same general area. But repeat violations are rising as a percentage of total OSHA inspections every year. Almost up to 5% now of all violations issued are repeat. And there's some interesting data on this. If you look at the breakdowns across regions, there was one region that issued more than 10% of their violations issued over the fiscal year 2015 were characterized as repeat. Others were in the 6 and 7% range. As an average, we came out around 5%. The reason why I talk about this so often is because this is the way until, Lindsay's going to talk about new civil penalty authority, but until OSHA was granted that authority, which was totally unexpected, OSHA has been searching for ways to drive penalties up. They go to the Hill every year and pound their fist on the table and say, we don't have sharp enough teeth. People can be punished more severely for mistreating cattle on federal lands than they can for killing their own employees, and we need higher penalties. So OSHA was not given that authority. Every year they asked for, OSHA reform legislation to push maximum penalties up. They couldn't get it, so they found creative ways to drive average enforcement action penalties up, and one of those ways is to find and cite more repeat violations, and this shows that effort has worked. OSHA has every year found more repeat violations, and of course those carry the 10 times higher penalties. So we've seen the average enforcement action cumulatively much, much higher. Even if, we look back at that slide, that average per serious violations are still, a pretty small number. When you start dealing with repeat and willful violations, you get into much more significant enforcement actions, and OSHA has found ways to do that over the years. With more repeat violations and more willful violations, we've seen that OSHA during the Obama administration has been able to issue more of these significant enforcement actions, cases involving penalties of $100,000 or more. Every year under the Obama administration, that number of $100,000 plus enforcement actions has been at least twice what we saw during the Obama administration. and the egregious cases and penalties with $1 million penalties or more, almost 4 times as often under the Obama administration. Another data point that I track every year is the enforcement press releases. You know, OSHA's effort to shame employers through negative publicity has been a very significant effort. They do this by putting out press releases the day that they issue citations. And these press releases, at least during the Obama administration, have been accompanied, every one, 100% of them, by a quotation from a senior OSHA official that is intended to embarrass the employer, uses inflammatory language about how the employer took shortcuts and didn't care about safety, and this incident could have been avoided, or the employer didn't take basic safety steps. Even when there hasn't been an incident or accident, you see that same sort of inflammatory language. So the tenor, the tone of these enforcement press releases has gotten more aggressive in the Obama administration, but so has the frequency of these enforcement press releases. You can see that during the final 5 years of the Bush administration, these press releases were being put out, about 150 of those a year, reserved for the most significant cases, generally those $100,000 plus cases and fatality cases. During the Obama administration, that has averaged over 460 press releases a year. You know, I'm not a mathematician, but that seems to be about 3 times as often. My understanding is that the press releases are going out for any enforcement action with a penalty of approximately $30,000 or more, or if it relates to some sort of novel issue. And so, you know, a $30,000 total cumulative enforcement action is a pretty ubiquitous set of OSHA citations. It doesn't take very much to get to that $30,000 level. And after Lindsay talks to you about the new penalty authority, it'll be even easier. So we'll see even more of these press releases. So something to, you know, again, the sort of the past is prologue, something really to look out for in 2016 based on what we know is coming. One thing that we review every year, although I'm not sure it's really worth the time we spend on it, are the top 10 most frequently cited standards. The reason why I say it may not be all that worthwhile spending time on this is that it practically never changes. In fact, the top 10 itself, the order shifts around a little bit every year, but the top 10 itself has stayed the same for many years, maybe even many decades. But it's still worth seeing as a reminder to you what that low-hanging fruit is, the things that, you know, you can expect, you know, OSHA to be looking for, or at least the things that they are well trained to find when they're in your workplaces. There's also a couple of, I think, noteworthy things here. Lockout, tagout rose in significance this year. I think that probably had a lot to do with the amputations national emphasis program, as well as the amputation element of the new reporting rule that we'll talk about in a moment. But these are more issues and incidents and injuries that are more on OSHA's radar because of the emphasis program and the new reporting rule, and that has resulted in perhaps more lockout, tagout violations, and I think we'll see more machine guarding violations as well. The other thing that's significant here, and that Dan Deacon will talk about later, is that hazard communication, although it's not new that hazard communication sits high on the list of frequently cited standards, but because of the continued rollout of GHS HAZCOM, I think that makes hazard communication an issue that ought to be a high priority for you in 2016, because we know OSHA will be looking at it. We know they look at it every year, but they'll be paying particular attention to it as the major deadlines pass for the rollout of the new standards. So that's going to be something to pay attention to. So other than just the data, what are some other significant things that happened in 2015 that we should learn from and that we should be paying attention to? Here are the 3 that jumped out to me. One was the new fatality and injury reporting rule that kicked in January 1st, 2015. I'll talk a little bit about that. Another is a Supreme Court decision in a case called Mortgage Bankers, which may have opened the floodgates for OSHA and other regulators to engage in some backdoor rulemaking, to change the rules as they apply to employers but to do so without going through notice and comment rulemaking. I'll talk a little bit about that. And then OSHA's temporary worker initiative, the drum beats on for that initiative. We'll talk a little bit about what OSHA's been doing and what you can expect going forward. So OSHA's new, although not so new now, we've had our 1-year anniversary with the rule, new fatality and injury reporting rule. This is a rule that changes about every 20 years or so. Started out that a fatality was reported to OSHA within 48 hours using the old telegraph system. I can say I'm not even sure I've ever seen a telegraph before. That tells you how slow-moving this rule has progressed. Fatalities were reported and continue to be a requirement to report, but in the original rule, employers only had to report incidents that resulted in the hospitalization of 5 or more employees from the same incident, and that was due to be reported within 48 hours. That was an extremely rare circumstance. One event that hospitalizes 5 employees happened, maybe 2 to 5 times a year across all industries across the country. So 20 years later, OSHA updates their rule and says fatalities have to be reported, but we want them reported quicker, within 8 hours. And they introduced a new 1-800 24/7 hotline through which employers could report as a new methodology for reporting. Then they also lowered from 5 employees to 3 employees hospitalized from the same event as an event that needs to be reported to OSHA. And even after making that change, that still was an extremely rare event. We saw about 12 to 25 of those a year that had to be reported to OSHA. This tended to be explosion events that would involve, several employees. But other than that, maybe some collapses, things like that. But otherwise, it was still very rare that 3 employees would be hospitalized. So really, OSHA was only hearing about the fatality events. And they thought they wanted to know more. They wanted to be involved in more. So 20 years later, they changed the rule again to now continue to require reporting of fatalities within 8 hours. But now, instead of hospitalization of 3 or more employees, it is reportable to OSHA if you have the hospitalization of a single employee. And added a couple of specific injury types that, whether they involve hospitalization or not, also have to be reported to OSHA, and those are amputations and loss of an eye. And hospitalization of a single employee, amputations, or loss of an eye have to be reported within 24 hours of when you learn about the reportable incident. OSHA also, in this new rule, introduced a new method for reporting. We went from the telegraph system to a new web-based portal. And this is a way that, you can, even on your iPhone, plug in some data and submit it to OSHA about a reportable incident. I will tell you, I think we've got a webinar coming up, and maybe even next month, what we've learned from the first year of the reporting rule, and I'll talk in more detail about this. But I would caution against using this web-based portal. We have a blog post on this issue up on the OSHA Defense Report. Read about it. I think it's either the last or the second to last article we put up there. So check out some more information about that. What has been the impact after watching a year of this in 2015? We saw a sharp increase in reports, although it was not to the level expected. OSHA projected that we would see 25,000 more reports because of the lowering of the bar to a hospitalization of a single employee. Instead, we saw about 12,000 reports. So OSHA's instinct, obviously, is not that there are fewer injuries, but that people are underreporting. So they're trying to crack down on that. And one of the things that I saw in the tail end, or the last quarter of 2015, was we really started to see OSHA issuing separate violations, willful violations, many of the times, for a failure to report. So they're really trying to emphasize and broadcast the new requirement to make sure employers are aware of it, and also to make sure that employers who are trying to skirt it realize that there are serious consequences for that. So that was one new trend I saw in the tail end of 2015, which I think can forecast some activity in 2016, is that OSHA, looking for failure to report circumstances and citing those very aggressively. Another big element of the new rule is OSHA's expanding their public shaming campaign by planning to, although I've not seen this really happen in any organized way, to publish the data that they are collecting from these incident reports. And this is another reason I'm concerned about the web portal, is I could see them just publishing the written submission that you make through that portal. So what else is significant about the new injury reporting rule? One significant development is a new, basically call it a triage program that OSHA put in place to handle this incredible surge of new reports that they were not receiving historically. OSHA cannot inspect all of these, so they put in place a program called the Rapid Response Investigation. And so unless you meet certain criteria, generally a fatality, hospitalization of 2 or more employees, or an incident involving one of their high emphasis hazards or something that they've got an active national emphasis program for, you are much more likely to receive by fax or in the mail a rapid response investigation letter. And this letter calls for you, the employer, to basically conduct an OSHA inspection, to do a root cause investigation of the event that you have just had, and then to report the findings of that investigation back to OSHA. And then with that information, OSHA may decide to initiate an inspection, although that is happening at a fairly low rate. So that's something to watch for in 2016, and we're still waiting for some data from OSHA, a report from OSHA, which I expect in the next month or so, that talks about, that dives deep into this data, the number of cases that were reported, the number that immediately triggered inspections, the number that triggered rapid response investigations, and the number of rapid response investigation responses that OSHA received that then triggered an inspection. I think that'll be interesting data to look out for here in the next year. One of the other big developments of the year that I mentioned was the United States Supreme Court's decision in Mortgage Bankers. Mortgage Bankers was not an OSHA case, but it was a case involving a Department of Labor agency, the Wage and Hour Division, the Wage and Hour Division issued a new formal interpretation. In the OSHA context, we call them interpretation letters. The Wage and Hour Division did that for issues that relate to wage and hour issues. And that interpretation was very different and imposed very different obligations on employers. And employers looked at that and said, hey, wait a second, if you're going to change the rules on us, the law has always required you to go through the Administrative Procedure Act's notice and comment rulemaking. And this is not a lawful way to make a rule by issuing an interpretation. The case was litigated up to the Supreme Court, and the Supreme Court, a very surprising move in my opinion, decided that it basically exempted from APA's notice and comment rulemaking process an agency interpretation, what they called interpretive rules or an administrative interpretation, even if that interpretation is exactly opposite to what the agency's longstanding interpretation may have been. Now, the Supreme Court said if an interpretation is opposite than what it's been in the past, we in the courts and any court that's reviewing that interpretation may use that as evidence to say that the interpretation is arbitrary or capricious, but that's an extremely hard burden for a litigant to make out against the government and the discretion that they are given, the deference that they are given. But the reality is agencies can issue a brand new interpretation that is opposite to what it's been in the past, that imposes new obligations on employers, and not have to go through notice and comment rulemaking to do that. At least that's on its surface what this decision seems to say, and that's certainly the position that OSHA has taken. The reality is the Supreme Court did say that interpretations that are legislative in nature, a legislative rule, does need to go through notice and comment rulemaking, although there's not a whole lot of clarity in how one distinguishes an interpretive rule from a legislative rule, but that is going to be a very significant issue that is already being actively litigated. Now, I say that, OSHA takes a certain position. OSHA was sitting there licking its chops, waiting for this decision to come out. And I talked to a couple of people in solicitors' offices around the country who told me that we knew this decision was coming out this term from the Supreme Court, told me that there were, to watch out for, a couple of very significant process safety management interpretation letters that OSHA has written and that are sitting on the desk and waiting for the mortgage banker's decision to come out. And if the mortgage banker's decision is favorable and grants agencies authority to change longstanding interpretations without notice and comment rulemaking, that watch out, we're going to start changing rules using interpretation letters. And sure enough, within about 2 to 3 months of the mortgage banker's decision being issued, we saw 3 very significant OSHA interpretation letters that change in pretty significant ways implementation, coverage, and the requirements under OSHA's process safety management standard. 2 of them, the first 2 listed here on this slide, about defining and implementing OSHA's recognized and generally accepted good engineering practice requirements in PSM, and the change in how you calculate whether a chemical mixture is a covered chemical. Both of those rules, the agency has been sued, challenges that these were not interpretive rules, but in fact were rulemaking without the following the steps of the APA notice and comment rulemaking. The retail exemption, there was also a suit filed about that, but Congress intervened, and with a rider in one of the appropriations bills last year said, no, sorry, OSHA, you get no money if you use any money or resources to implement this new interpretation. So basically eliminating the retail exemption interpretation letter from having effect. The other 2 rules are in active litigation, and it will be very interesting in 2016 to see what happens on that front. Final thing I'm going to review before we stop looking backwards and we start to look forward to 2016 is the OSHA's Temporary Worker Initiative. OSHA was very concerned, has been growing increasingly concerned about how temporary workers are treated in the workplace. And those concerns generally stem from the feeling that OSHA had that employers were using non-full-time employees, non-permanent employees, outside workers to do the dirty jobs, to do the jobs that were the most hazardous, and using them because they felt, host employers felt, these are not my employees, I don't have OSHA obligations to them, so let's use them for the hazardous jobs. OSHA also felt that that this class of worker, temporary workers, were a particularly vulnerable class of workers because their relationship with the employer and their status with the employer is more tenuous. So these are folks who are less likely to speak up if they observe an unsafe practice or if they're asked to undertake an unsafe practice, and they're more susceptible to retaliation. OSHA also felt that employers were deliberately not providing the same level of training or any training to temporary workers because it was not viewed as a worthwhile investment because those workers were not going to be there long term. And then OSHA was, remarked, at least anecdotally, about a set of high-profile fatalities and serious injuries that were happening, so to speak, on day one on the job, very early at a new workplace because they felt these workers didn't have the same training, didn't have the same experience, and were being hurt and were doing the more dangerous jobs, and therefore OSHA was very concerned about those employees. And then OSHA also recognized what is expected. Most people project that the temporary workforce is going to grow, at least in part because of the Affordable Care Act, as those requirements roll out for providing health care coverage when you meet certain thresholds for numbers of full-time employees, that employers are likely to use more part-time and temporary workers to stay below those thresholds. So this is going to be a growing element of our nation's workforce. And so OSHA was concerned about it. So back in 2014, announced the launch of a temporary worker initiative, and throughout 2015, we watched them implement this initiative and what that has meant for American workplaces. And what we saw through this was OSHA's effort to do several things. Their goals were protect temporary workers, ensure that host employers and staffing agencies understood what their obligations were, and then OSHA was trying to learn, digest a lot of information about the use of temporary workers. What industries are using the most? What types of jobs are they being asked to do? And we can expect, I think, that the data that OSHA has been collecting through the first couple of years of the initiative will inform enforcement programs going forward. I think once OSHA has a good sense of what industries are using temporary workers most, they're going to start targeted inspections in those industries, looking for how those employers are treating and handling their temporary workers. So this temporary worker initiative applies to employees who are coming through a staffing agency to a host employer, and compliance officers were instructed to look in any inspection, no matter what the trigger was for that inspection, to look for whether temporary workers are being used, what jobs they're being used for, and whether employers have met their obligations vis-a-vis those temporary workers. And the big takeaway, and we could talk about this for a long time, there's actually a recording in our archive from the 2015 series, webinar series about this temporary worker initiative, but the biggest takeaway from this has been joint responsibility. That is the mantra coming out of OSHA, that host employers need to treat temporary workers just as they treat their full-time employees, and that staffing agencies and host employers share control over those employees, and therefore they are jointly responsible for their safety and health. And as a practical effect, or as a practical result of this joint responsibility mantra we're hearing from OSHA, is that when we see incidents involving temporary workers, OSHA is issuing citations to both employers, or at least to the host employer. So this is a big issue to continue to pay attention to and to continue to think about how you're handling your temporary workers. And again, check out either the article we have on our OSHA Defense Report blog about the temporary worker initiative, or our old webinar about this topic, where we go through some best practices for how to deal with this issue. With that, I'm going to hand it over one by one to my colleagues to start talking about the top 5 issues to look for in 2016, and we'll start it off with Lindsay Smith.
All right. Good afternoon, everyone. My name is Lindsay Smith, and I'm actually an associate in the OSHA group, as well as the Employment and Labor group at Conn Maciel. I am fighting a bit of a cold today, so if you've been hearing coughing in the background, that's me. But I will do my best to try to control my coughing during this part of the discussion. So I'm going to spend just a little bit of time now talking about this rise in OSHA civil penalties that's set to take place in 2016. So it was really surprising to us that OSHA penalties will increase and could potentially skyrocket in 2016 under the currently Republican-controlled Congress. As Eric mentioned, although OSHA has tried to increase penalties many times prior to this through lobbying and legislation like the Protecting American Workers Act, it had traditionally been completely unsuccessful. However, this mandate, which is called the Civil Monetary Penalties Inflation Adjustment Act, snuck into the 2-year Bipartisan Budget Act of 2015, which was signed into law on November 2nd. The budget was passed on the verge of a potential government shutdown, so there's a good chance that many were unaware that this provision was in the Budget Act. Nevertheless, OSHA, pursuant to this mandate, must now implement an adjustment by August 1st of this year. And this will actually be the first increase in OSHA penalties since 1990. So it is now within OSHA's discretion to determine the exact increase in the penalty level, and it can go up to almost 80% of the current amount. And the adjustment is actually tied to the percentage rise in the Consumer Price Index since that last increase in November 1990. Effectively, this amount was determined by comparing the CPI in October of 1990 to the CPI in October of 2015. And based on that comparison, it rose to that 78% level. So if OSHA chooses to increase the penalty levels by 78%, it can do so pursuant to an interim rule, which will allow the changes to become effective immediately upon the rule being promulgated, published in the Federal Register, with the comments from stakeholders like employers to be solicited after the fact. However, if OSHA chooses an amount less than 78%, it would have to follow a more traditional rulemaking approach. So, in our opinion, OSHA will most definitely jump at this opportunity to, raise the penalty amounts to that maximum allowable increase, especially given the fact that it has tried to, really get these increases in the past. As Eric talked about, it was complaining about the fact that they don't have enough teeth. So this gives them that opportunity, and it's also a greater rulemaking burden that OSHA would face if it decided to raise it to an amount less than that maximum penalty. So this table demonstrates the change that would take place if OSHA decides to raise the civil penalties to that maximum 78% amount. You'll notice that for other than serious and serious penalties, you could see an increase of up to about $12,500 as a maximum penalty. And then for willful and repeat violations, it could actually go up to about $125,000. If we think about this in terms of, a typical enforcement action with maybe 2 to 3 serious violations, if you're getting a citation package that has even just 2 serious violations, this could shift from a maximum penalty amount of $14,000 to potentially a cumulative penalty of up to $25,000. And then if you add in just 1 repeat or 1 willful violation, all of a sudden that total penalty amount is in 6 figures for just 1 willful or repeat violation. And as Eric pointed out earlier in the presentation, OSHA has been continuously, finding more repeat violations. So this outcome of getting up into a 6-figure penalty is, even more likely. So what does this mean? What are the consequences of implementing these higher penalties? Well, I think the most obvious one, as I was just kind of talking about, is this increase in the total penalty amount we could see in enforcement actions. And obviously that increase is very significant. Although it's unclear as of now what exactly OSHA will do with this new penalty authority, its agenda throughout this administration has been very enforcement heavy, and it has put forward significant budget funds toward enforcement programs. So at least for now, this authority will likely continue down this path, and we can see, some pretty significant enforcement actions. The average penalty assessed by OSHA was, around less than $3,000 this year, just a little over $3,000. So, it is clear that OSHA often does not actually, cite employers with the maximum penalty amount. However, even if OSHA chooses to assess the penalty below the maximum, so if that maximum does go up to $12,500, likely below this amount will be the average, but that could still mean around $6,000 to $7,000 for a serious or other than serious violation. And obviously, that's a pretty substantial increase from what we've been seeing in the past. Additionally, as OSHA policy currently stands, employers are more likely to get that negative press release with the enforcement action because, currently they do that for around $30,000 for enforcement actions that are around $30,000 or greater. And so with these increases, just 3 serious violations around the maximum penalty amount, and you're already hitting that $30,000 level and may see a negative press release. And those press releases can cause serious harm to an employer's reputation, particularly if they include one of those inflammatory quotes or depict the company as indifferent to employee safety. This is furthered by the fact that the press releases are actually maintained on OSHA's website forever to be accessed by the public whenever it chooses. So, that impact could be felt years into the future. And then finally, this penalty increase is likely to be most impactful for first large national employers with multiple workplaces. Obviously, with multiple workplaces, the way that OSHA's policy on repeat violations works, you could see, repeat violations for an incident or an enforcement action that occurs at a different establishment. That could be the basis for a repeat. So large national employers with, a number of different workplaces could see more repeat violations at that increased amount of potentially $125,000 if the maximum penalty is assessed. It'll also significantly impact citations related to serious injuries or fatalities. Those are the cases where OSHA is really looking to try to assess a willful or repeat violation, or at least have a number of serious violations. And those are the cases where, they're going to be more likely to assess that maximum penalty. You have employers who OSHA view as bad actors. These are often the SVEP cases. And, if an employer is being entered into SVEP, that means you have at least one willful if it's related to a fatality, or you could have 2 willfuls, a willful and a repeat, and then you have potentially $250,000 in a maximum penalty if you have a willful and a repeat. And just to clarify, because we haven't really gone over this so far, SVEP is the Severe Violator Enforcement Program. And it's something that, if OSHA comes on site and assesses a couple of willful violations, you can be entered into the program. There's a number of ways to be entered in, and although we don't discuss it in this presentation, we will discuss that in more detail in future presentations. And then finally, those most likely to feel the impact of this significant penalty increase are those employers who are receiving violations in certain high emphasis categories. So similar to the prior two, if it's a high emphasis hazard, OSHA is going to want to push more for that maximum penalty amount and potentially be even more likely to try to find the basis for a willful or repeat violation to really drive home the fact that this is an important category for enforcement action.
There's one other thing about this new penalty authority that I think is worth talking about, and I have seen some, I think, sort of confusing statements in articles from others that I've read about this. The idea that OSHA has this authority now to raise penalties up to 80%, and I've seen predictions where that, in fact, they may not exercise that full authority. My expectation is quite contrary, that OSHA probably thinks that this authority they've been given is still not even enough. So I fully expect them to do the maximum penalty increase that they can. In other words, raise the maximum penalties the full 78%. And there's 2 reasons I think that. One is that they want the maximum authority they can have. The other reason is the actual legislation requires OSHA to make this increase. And if they make the increase by the maximum amount, they can do it through an expedited rule, which means they publish the rule and it is instantly effective. It is instantly the law of the land. However, if they raise the maximum penalty amount by some lesser percentage, if they don't use the full 78% and only raise it 50%, then they have to go through regular notice and comment rulemaking. So they would be getting lower penalty authority and taking on a higher rulemaking burden. So it strikes me that there's no way that they're going to do that. So look for sometime between now and August 1st for OSHA to issue the full maximum increase that Congress has granted them here.
All right, and with that, we'll turn it over to our next speaker.
Hi, my name's Amanda Walker, and I'm a partner in Conn Maciel's OSHA practice. And like Eric, I practice exclusively OSHA law and was previously with the Department of Labor and OSHA and the Solicitor's Office, where I focused on occupational safety and health. And Lindsay talked a bit about the rise of penalties, and I'm going to talk about the rise or the suspected likely rise of prosecutions, criminal prosecutions on the rise under the OSHA Act. Since the OSHA Act was developed or started in the early 70s, one of the provisions in it allowed for OSHA to issue or refer cases to the Department of Justice for criminal prosecution. Specifically, Section 17E of the Act provides criminal penalties, including imprisonment up to 6 months or penalties up to $250,000 in fines for individuals and $500,000 for organizations. OSHA's been somewhat limited in using this authority. They have several times over the past 30, 40 years, but it has been few and far between. Both organizations and officers or directors in particular circumstances can be prosecuted under the criminal provisions of the OSHA Act. Turning to the next page, one of the reasons that we haven't seen so many of these is the elements that Department of Justice and their criminal prosecutors would have to prove in order to succeed on a criminal charge under the OSHA Act are pretty high and difficult to meet. It includes 4 elements. There has to be an OSHA standard violation. It could not be a general duty cause, so it has to be one of the regulations, specific regulations that's currently on the book that was violated. The violation has to be committed by the employer, and the violation or standard has to have a direct cause to the employee's death. They must prove beyond a reasonable doubt that the conduct which amounts to the violation of an OSHA standard was both the cause in fact and the legal cause. So it's a pretty high burden. And then in addition to that, they have to show that there was a willful violation. And in OSHA terms, that means that they have to show that there was a deliberate action taken by the employer with knowledge of both the hazardous condition and the OSHA Act's requirements. And with all 4 of these elements combined, it's been a pretty tough or high burden for criminal prosecutors to meet with regards to charges under the OSHA Act. Turning to the next page, in the over 400,000 fatalities since the OSHA Act was enacted, there's only approximately been 80 criminal referrals, a few a year, about 2 a year, and there's been a dozen criminal convictions. And most frequently, these criminal convictions have to do with companies rather than individuals. There's odd circumstances on occasion where individual will be so ingrained and so part of the corporation where they are actually considered to be the corporation, but those are not frequent. However, under this administration, criminal referrals have been increasing, certainly have been seeing more than in the previous administrations. I think under the previous administrations, we would see probably about 10 a year of referrals, not necessarily indictments or convictions, but the actual referrals. Certainly seems to be increasing. There's been some discussion that there's an automatic referral any time that there's a willful violation in relation to a fatality. This hasn't been confirmed, and we have seen a couple cases where there was a willful violation that seemed to be very closely connected to the fatality, and there didn't seem to be a referral with it. But I would say a vast majority of the willful violations issued by OSHA that are related to a fatality certainly do get a very, very close review, even if they are not referred. But I would the vast majority are referred to DOJ for further investigation. So having said that, the high standards that OSHA has to meet or Department of Justice has to meet in order to prevail in a case, they've not found these types of cases to be particularly interesting or worth their time. They typically target criminal activity related to OSHA under other statutes. Has to do with falsifying records or lying to an OSHA investigator when they're out on site, chronic violators and employers who demonstrate a systematic rejection of worker safety laws. When an individual has repeated violations over and over again, that certainly increases their likelihood that an appeal for the criminal prosecutors to pursue that case. And cases that are intertwined and have both the safety component as well as the also environmental law violations, given that environmental laws often have much higher penalties as well as much stronger criminal sanctions. It's much easier to prove a criminal violation under an environmental standard than it is under an OSHA standard. Going over to the next slide, other violations that trigger criminal sanctions: falsifying OSHA documents, making documents, falsifying them and providing them to OSHA under misrepresentation or under terms on when they were created, advance notice of an OSHA inspector. This is really, we see primarily this is focused on compliance officers, not on actual individuals or employees in the OSHA context. Perjury during OSHA proceedings, providing false testimony or false documentation or trying to mislead OSHA or somehow impede their investigation. We've seen several prosecutions under those types of, as a result of those types of actions. Violation of environmental statutes. If there's a fatality with regards to an environmental component to it as well, that often you see the prosecutors much more interested in the criminal aspects of the occupational safety and health standard in those cases. And then there's also the violations of the state criminal laws. The death of an employee can also trigger manslaughter or neglect homicide charges under state law. So OSHA sanctions are not the only ones that are potentially applicable to the employer from the context of the occupational safety and health perspective. Moving on, one of the reasons that we think that OSHA is we're likely to see a rise in criminal prosecutions in this coming year is a new memorandum that was issued by the Department of Justice in December. This is a memorandum of understanding. It was issued between DOJ and DOL. It actually came out under DOJ letterhead, and it directs all 93 U.S. attorneys to pursue individual corporate wrongdoing with a focus on worker endangerment. This was issued by the Deputy Attorney General, went out to all Attorney Generals, and basically says that they find the current statistics with regards to workplace deaths and injuries, which fatalities are currently running about 4,679 per year, as troubling, and they want to hold employers accountable. So they're looking at ways to increase the number of criminal prosecutions. The memo, one of the big changes in the memo that works towards that end is the reassignment of cases in the DOJ. Previously, cases were in the criminal division's fraud section. It's now occupational safety and health criminal referrals will now go to the environmental crime section. The rationale for supporting this change was worker safety violations often incur in conjunction with environmental offenses, and the federal air, waste, and toxic exposures can be charged as felonies, so there are more severe penalties related to them, and proving environmental crimes is much easier. So having kind of the OSHA side of it in conjunction with the environmental crime section would probably make it more likely and more appealing for the criminal prosecutor to move forward with those criminal prosecutions under occupational safety and health issues. The other changes that will likely result in the increase of OSHA Act prosecutions, more robust information sharing between DOJ and DOL. DOJ has also spent a substantial amount of resources in training OSHA inspectors so that they know what to look for early in the field with regards to criminal prosecutions. If they feel as though early on in the process that they have a potentially criminal matter on their hands, just the documentation that they'll need to have, some of the criteria, and how to basically develop the file. There's referrals between inspections, so now that this is all within one group in DOJ, environmental to occupational safety and health, the referrals between the two cases are likely to occur much more frequently. One thing in addition is there's designated points of contact within DOJ and DOL. Before, there wasn't really a designated channel for criminal referrals from OSHA to be made. Now there's certainly contact people, people that will be able to start tracking the referrals. A lot of times a referral will be made and will not have notification throughout the entire agency. It might be something that's more local. This will definitely help keep a focus on the referrals and keep notes on the status of them as well as their statute of limitations, which is 5 years after the event did occur. And those are some of the reasons why we think that we'll see criminal prosecutions on the rise in 2016. Now turning it over to the next subject matter, OSHA rulemaking.
Good afternoon, everyone. It's good to talk to a lot of you again. A number of you have participated in many of our 2015 webinars, so we're glad to talk to you again. And for those of you who are new, I want to raise a topic that I talk about a lot in our webinars and other places. I've been around the OSHA rulemaking scene for probably more years than I'd like to admit. And I thought maybe what we do today is do something a little bit different. I want to give you a sense of what to expect in 2016, but I thought maybe the way to do that is reflect back on 2015 and really the previous 8 years, the Obama administration, and what's happened with rulemaking in the administration. We had an interesting phenomenon. We had a Democrat come into office, guns a-blazing. We had a lot of talk in the beginning of the Obama administration when Jordan Barra became the acting head of OSHA, awaiting Dr. Michaels' confirmation, and then ultimately Dr. Michaels was confirmed and stepped into the role. And we know that there was a lot of effort, desire, passion on the part of the administration to really ramp up the rulemaking process to fix what I think everyone would acknowledge, both at OSHA as well as in industry and even I think labor unions, which is a broken rulemaking process. And there was a lot of hope and energy at Constitution Avenue at the beginning of the term to really have a very aggressive rulemaking process with a lot of new rules to help with health and safety of and protection of employees. What we saw, though, was very different than what I think the expectation was. We're now, sort of in the very tail end of the Obama administration and Dr. Michaels' tenure over at the agency. And if you look at the November 2015 semi-annual regulatory agenda that was issued a couple months ago, you'll see that we see that same sort of hope and energy. We see a very aggressive schedule for rulemaking. We've got 13, regulatory actions that have been identified. These are the agency's priority actions that it would like to move forward and would like to move forward aggressively. We have 11 rules identified in the final rule stage, and we've got 6 in the proposed rule stage. So the end of the term, we see an aggressive schedule. But, to me, that is a little bit of fiction or maybe, hope that hasn't panned out. In reality, what we've seen on the enforcement side, certainly the agency has been very aggressive and very effective in really ramping up enforcement. But on the rulemaking side, the reality of it is we've seen an agency that, to my mind, has never really had the full backing of the White House for an aggressive rulemaking agenda. If you look back over the 8 years, what we see really is we see Dr. Michaels coming into office with a couple of really important priorities to accomplish on the rulemaking side. One was, his thing, which is I2P2, the injury prevention and it's called a lot of different things, but I refer to it as I2P2. It's basically a full comprehensive safety, health, and management program that would be imposed and implemented at every employer across the nation. It was, I think, in the beginning of the term, his top priority. He was never able to garner the political support to move forward in developing an I2P2 regulatory program. So that sort of went by the wayside. Now, when I say by the wayside, what I mean is it's not going to be a regulation. The agency essentially gave up on promulgating I2P2 as a regulation. They do work hard and are very creative in finding ways to get I2P2 into employers' workplaces through, for instance, corporate settlement agreements and other mechanisms and tools they've got. But it's certainly not, obviously it's not a regulation, nor will it be in the near term. Revised ergonomics program. A lot of people thought in the beginning the agency absolutely was going to undo what Congress undid at the beginning of the Bush administration at the end of the Clinton administration, the ergonomics rule was promulgated. And the Republicans used the Congressional Review Act to, for the first time ever, undo a rule that was a final rule. So ergonomics went away. A lot of people thought it's going to come back, never did. Another big important priority for Dr. Michaels was revamping the chemical rulemaking process to make it more effective. There's been some RFI, there's been some work done by the agency, there's a request for information that's been issued, there's been some activity, but we really haven't seen, I don't think we've seen major progress in that area. Combustible dust, similar sort of thing. The agency was absolutely bound and determined to do a combustible dust standard. And they got really bogged down. And we, at the end, 11th hour of the Obama administration, there's no sign that we're going to have combustible dust come back as an active rulemaking. Hearing conservation program, you remember back in the day, the agency wanted to make a major change to the hearing conservation program to prohibit PPE from being used to bring noise levels down to appropriate levels to protect workers' hearing. They wanted to have engineering controls implemented. That the White House did not support that. They did not support the inclusion even of a MSD column on the OSHA 300 log. So bottom line is we've had almost 8 years under Dr. Michaels, and we haven't really seen a lot of accomplishments on the rulemaking side. And that is the case notwithstanding this most recent very aggressive regulatory agenda that we saw last November. Okay, so that's sort of the backdrop. Let me talk now about what we do expect to see in 2016. I think we'll see some movement. The agency may make some progress. We understand that OSHA has a very few, only a couple of priorities that it can push forward in 2016 to possibly get to final rule before the end of the term. And I believe that the Department of Labor has about 16 slots available to it to put rules forward at the Office of Management and Budget to, advance the rulemaking process. Of those 16, OSHA has 2. So OSHA's got to prioritize 2 rules to get done in the 2016 term, at least, according to the information we have. Our prediction, my prediction, what I believe will be the 2 rules that the agency puts forward, puts the most emphasis on, and really tries to get finalized: silica and the record-keeping data submission rule. Those are as I understand it, as we understand it, the two rules that we think the agency is going to put all force behind to get done. So let me talk about, and those are two of the 31 items that appear on the regulatory agenda. Let me talk for a minute about these two rules. Silica. I'm not sure how many of you in this webinar today are concerned about silica, but as you all probably do have a general understanding of, silica is a component that is essentially ubiquitous. It is everywhere in everything. So it impacts a hugely broad swath of employees of companies across the nation. I think there are, and I'm not going to say how many employees affected because I don't quite remember, but it's a huge number, and it's a huge number of industry sectors that are impacted. Now, there's little doubt that silica is a human lung carcinogen and that it causes silicosis. The issue with this rule is not that there's a lot of question about the fact that exposure to crystalline silica, at least at certain levels, will cause silicosis and is a carcinogen. OSHA has done, and in fact NIOSH has done, a tremendous amount of work in this area where there's strong correlation between those adverse health effects and exposure to silica. Accordingly, the agency for many, many, many years, well before this administration, has wanted to promulgate a crystalline silica occupational health standard. There is a table Z limit for exposure to silica, but there is no occupational health standard. The proposal, which was issued a number of years ago, and by the way, it came out in proposed form only after years of OMB holding the rule up, and that's under this Obama administration. But it finally was able to be issued a couple of summers ago, and it came out. The proposal proposes to cut by half, cut by 50%, the current existing Table Z limit for exposure to crystalline silica from 100 micrograms per meter cubed to 50. It also proposes to apply that same limit to the construction industry. Right now there is a construction standard, but it's not, it's sort of calculated in an antiquated way, and it's, I think, by all accounts recognized as a high number. So the core of the change would be to cut the Pell by half. There'd also be a full, suite of ancillary provisions, just like OSHA's other health standards, with exposure monitoring, personal protective equipment, medical surveillance, engineering controls, record keeping, the whole gamut. OSHA's estimate is 1,600 avoided cases of silicosis, 700 lives saved. Now that's what OSHA's current risk assessment shows. The biggest problem that industry has identified with this rule going forward is not that there's question about the adverse health effects as much as there is huge question about whether it's needed any longer. What industry has believes and has submitted a lot of comment to the record on is that the regulation is antiquated, but nobody's at the level of the regulation anymore. Everybody across the board, across industry, has dramatically reduced the exposure levels that its workers are facing. And so the rule will cost a tremendous amount, but really have very little benefit because we're already essentially there. It's unnecessary, essentially, is industry's position. So let me just, but notwithstanding, we believe that this agency, Dr. Michaels and his team, are going to work very, very hard in 2016 to get this one across the finish line. The slide that's in front of you sort of shows how the rule developed. We did see, as I mentioned, a big OMB delay, but it finally came out in 2013 in proposed form. Comment period, hearings, the whole post-hearing process, it's all done. It's now, as of December of last year, it's been released by the agency back to OMB for the second trip over to OMB to get final approval in order for the agency to promulgate in 2016. we don't know. I don't know. I don't think anyone knows. I don't think Dr. Michaels knows what's going to happen really at OMB. Maybe he does. I don't know. But in any case, I know it's his hope and desire to get it promulgated. So do look out. If this rule could affect you, be very focused on whether, 2016 has a final rule on silica. The second rule that we expect, based on our discussions with OSHA, may in fact be the rule that the agency is going to push over the finish line, is the electronic rulemaking, electronic record keeping standard, or the injury and illness record keeping rule. It's it's referred to by different names, but what it does in a nutshell is it affects essentially two groups of employers. Employers with over 250 workers. What it will do for those employers is it will require the submission of OSHA 300 logs and OSHA 301 incident reports to the agency on a quarterly basis. Huge change from how the current process is done. Second thing it will do is for employers with over 20 employees in certain identified high hazard industries, and there's a list in the proposed rule, those employers that fall within those industries and have over 20 employees will have to submit their OSHA 300A injury summary forms to the agency on an annual basis. Okay, what's the impact? If this goes forward, it essentially is going to triple the number of employers required to report injury and illness data to the agency. Currently, you keep your logs, everybody keeps their logs, but you don't submit that information to the agency unless you've been identified by the Bureau of Labor Statistics and you get a letter from the BLS to tell you to send in your data. But only for instance, if you look at this chart we put together, 38,000 right now, employers with over 250 employees submit data. If this rule goes forward, it looks like we expect about 130,000 employer sites will have to submit data on a quarterly basis. That may result in the submission of over 1,000,003 recordable incidents provided to OSHA for the year. For employers with over 20 employees, it will almost quadruple the number of sites that will have to report injury and illness recordable data to the agency. Okay, so I think Eric mentioned at the outset of our webinar that the secure website where this information would be submitted electronically, because that is in fact a big requirement of this rule, that it's submitted electronically, that is available now. It's up and running. It's not open to submit because the rule's in proposed form, but it is designed and it's available to take a look at the model that's on the website, on OSHA's website. Other things we want to tell you about, big concern that the industry raised was that this rule is going to raise a risk of underreporting. This information that will be submitted to OSHA, if this rule is finalized, the agency has said will be made public. There's no doubt about that. That will be put in the hands of union organizers. It will be put in the hands of your competitors. It will be out there in the marketplace. It will impact consumers making decisions about which company to buy from in this, green era. And so that information is going to be out there. There's concern that it will incentivize employers to underreport because of the major impact it may have, way outside the scope of what the injury and illness logs were intended to do. So as a result of some concerns raised about underreporting, the agency in August 2014 actually reopened this rule and added a couple of additional provisions to the rule for comment, which were to basically require, in order to combat this concern about underreporting, to require employers to inform employees of their right to report injuries and illnesses, to prohibit employers from establishing unduly burdensome reporting requirements that would be due immediately upon, an injury, and to remind employees that employers cannot retaliate against employees for reporting injuries and illnesses. Now, all of those things are already, those are additional requirements the agency is created that industry believes is not necessary. There is the whistleblowing provision of the OSHA Act, and that prevents employers from retaliating. So this is sort of duplicative of the whistleblowing provision, and a big criticism of this rule, of the revised rule proposal. In addition to the concern about underreporting, there are a lot of other concerns about this rule. First of all, the agency never did a particularly good job of identifying a foundation for why, from a health and safety perspective, not from a union organizing perspective or a consumer perspective, why it wants this data. There's also concern about how the agency could possibly handle all of this data that it gets. Remember, I said it'll be over 1.3 million recordable incidents put in OSHA's hands. What are they going to do with that? How will they analyze it? What will be the result of it? Again, there's concern that it will be used by union organizers as a point of leverage to organize a facility, which is a huge concern on the industry's part. A final concern that I want to raise is that, when the original record-keeping rule was promulgated, the entire basis for the requirement to keep these OSHA logs was not based on fault. The assumption was not that the employer's at fault and that's why a particular recordable incident occurred. It was that there was a purpose that would be served by having employers themselves understand where the incidents were occurring at their facilities so they could address it. No fault of their own, potentially. Could have been employee error, could have been, just a straight-out accident. But whatever it was, the assumption was this was a no-fault record-keeping policy. By promulgating a rule that will allow for this data to be put out to the public, it almost inevitably will change the foundation of this no-fault policy and result in this rule, these logs, being used to point fingers at or find fault with the employers for, essentially an unsafe workplace. Okay, just a couple of minutes on another rule, which is in proposed form. It relates to the record-keeping standard. In 2012, a major case was decided by the D.C. Circuit, referred to as the Volks case. That case basically affirmed that OSHA's the OSHA Act's 6-month statute of limitations applies in the record-keeping context. That is, that if you have a recordable incident at your facility, under the regs, you have 7 days to record that incident. If you have not recorded it on the 8th day, you are in violation of the record-keeping rule. OSHA has 6 months from that 8th day to bring in action under Section 658 of the OSHA Act, which is the 6-month statute of limitations. That decision, that clarity was of the application of the statute of limitations to the record-keeping provision or record-keeping regs was brought to a head in the Volks decision, and the court affirmed this application of the 6-month statute of limitations. OSHA then, in July of 2015, issued a notice of proposed rulemaking. The title of it is on the screen there. Basically what it does is it's an end run around the Volks decision. It says that the employers have a continuing duty to keep their record-keeping logs. It essentially, de facto, extends the time period for which you have to write down on your log a recordable incident to the entire limit of when you have to maintain those logs, which is 5 years, plus the 6-month statute of limitations. All right, so
one thing I add, the reason why we talk about this particular rule here is that this understanding we have that OSHA only has 2 slots at OMB, I would not be terribly surprised to see OSHA try and mush together this Volks rule, the statute of limitations record-keeping rule, with the data submission record-keeping rule to try and sort of suggest that it's one rule change, amending the record-keeping standards to try and get more done before the end of this administration. Otherwise, it's really just the first two that Kate talked about that we think are realistic changes for the balance of the term here.
And I'm just going to spend 20 seconds and then turn this back over to Eric to finish up. 20 seconds on what else there may be out there. One thing I want to point out, the walking working surfaces rule, 1990 it was first proposed, 2010 it was reproposed. OSHA really wanted to get it done. The solicitor's office really wanted to get it done. Everyone thought it was going to get done, and it's not particularly controversial. Notwithstanding, just a couple of months ago it was pulled back from OMB, so there may be trouble even getting that one done. But that one's one to watch for. Also on the chemical safety side, there is a beryllium standard. There'll be a proposal out there. There'll be a hearing in just a couple of weeks on January 29th. There's great hope, I know, on the part of the industry as well as labor unions that standard may be promulgated. I know OSHA wants to do it. Whether it will happen or not in this term is up in the air. And that's basically, sort of what we expect for 2016 for OSHA rulemaking.
So, anybody who's met me knows that I can talk over any time limit I give myself by myself. Combine 5 lawyers, and we're destined to go way over any time limit. So if anybody has to drop off, I totally understand. We will try and zip through the last 2 topics quickly. Again, we are recording the webinar, so if you have to leave and you're interested to hear about the next 2 topics, you'll have an opportunity to do that to listen to the recorded webinars. The next topic, Kate covered OSHA rulemaking, sort of traditional rulemaking that is being led by the Occupational Safety and Health Administration and what to expect in 2016. And we believe there's only these 2 slots that OSHA has to promulgate rules, but there is another rule that has I think a very significant has great OSHA significance that we think has a chance to be promulgated still under the Obama administration, but it's not being spearheaded by OSHA directly. This is the FAR Council and Department of Labor working jointly to promulgate a rule in furtherance of President Obama's 2014 Fair Pay and Safe Workplaces executive order. And this was an executive order about impacting how the government evaluates the contractors that the government will do business with, and essentially saying the government should not do business with contractors who are not who do not respect their HR obligations and their labor obligations. And the gist of this has been identified by a FAR Council proposed rule, and really the meat of it was introduced to us by a Department of Labor guidance document that were issued in conjunction with each other. And this guidance document would inform how this new rule would be implemented. And the rule is about disclosure of and how the government will treat the disclosure of labor law-related violations by those federal government contractors who would endeavor to do business with the federal government. And here is, as quickly as I can, the meat and potatoes of this rule. What must be reported? All administrative merits determinations, which includes alleged violations. If you receive a citation, even if you're contesting it, even if it is profoundly wrong, it is an administrative merits determination that you have to report as part of the government contracting process. It also includes administrative merits determinations, also include things like administrative complaints, and then perhaps the only appropriate thing in this entire category is findings and adjudications of some judicial function of an enforcement agency. So when your citations are finally adjudicated by an administrative law judge or the OSHA Review Commission or a circuit court, then that determination is also an administrative merits determination that has to be shared as part of this proposed rule. When do you report? You report your labor law violations under this litany of labor laws. It's 14 federal labor laws and their state counterparts. So at the end of the day, when the state counterparts, state wage laws, state minimum wage laws, state OSHA program violations, all of that taken together, you're talking about, 100 to 300 different labor laws of any violation, including alleged violations, that have to be reported to the government in the government contracting process. You report them at the initial bidding stage, you report them at a pre-award stage, and then you report them semi-annually throughout the life of whatever contract you're engaged in. So it's a significant burden capturing all of these violations to do the reporting, because if you look at the different labor laws that are swept up into this program, I know that there's not one of my clients that has a single division within its organization that tracks all of these laws in one place. So this is going to be an administrative challenge to pull it all together and to report it on this periodic basis, and that's just for one contract. If you're a big government contractor and you've got dozens of federal government contracts going on at the same time, and you've got this semi-annual reporting requirement and reporting for new contracts you're bidding on, you could be in reporting mode essentially continuously. And then what happens if you report these things? The idea is that the contracting officers within the agency you're trying to do business with will evaluate your labor compliance history and determine whether the violations or the collection of violations are so significant that they should reject your bid, that they perhaps could rescind an active contract. They could even recommend debarment, basically prohibiting you from ever doing business with the government again. Or, and this is the big new component here, the government has always done responsibility determinations, and if you don't meet the requirements of their responsibility determinations, it can affect your ability to get government contracts or to keep government contracts. But now they're putting some sort of lowering the bar for what might impact your responsibility determination. But they've also introduced a couple of new things, and that is this labor compliance agreement and or the concept of demanding remediation for labor law violations and OSHA violations even before you've been proven to have actually committed a violation, just based on the allegations of the government. And how does that concept work, this labor compliance agreement and demanding remediation? Well, first let me talk a little bit about what it is that's likely to have those impacts, what might trigger a rejection of a bid or debarment or things like that. They say in this proposed rule and the DOL guidance that the focus of the analysis, in other words, the labor law violations that will be most important in determining your responsibility determination, are those violations that are most concerning and have the greatest bearing, are those that have are characterized as serious, willful, repeat, or pervasive. So willful, repeat, and pervasive, I sort of understand where the government is coming from, but serious in the OSHA context is crazy. The idea that we're saying that the focus of those violations that are most likely to lead to you being debarred or losing bids or losing active contracts is anything characterized as serious. In the OSHA context, everything is characterized as serious. At least 75% of violations, OSHA violations that were issued for every year since I've been tracking this, have been approximately 75% have been classified as serious. About 85% have been classified as serious, willful, or repeat. So that means almost every OSHA violation are those types that are so concerning and will have the greatest bearing on your assessment of your integrity and business ethics. So I think OSHA, Department of Labor, and FAR have set the bar in the wrong place. So this would have a huge impact on contractors' ability to do business with the government. And how are they going to implement this? What is the practical effect? There is the introduction of a new government position called an Agency Labor Compliance Advisor. And these Agency Labor Compliance Advisors, ALCAs, are an individual who will be with each government agency that engages in contracting. So the Department of Defense will have its own ALCA or set of ALCAs who will consult with contracting officers and with the accusing agency. So, for example, if you have an OSHA citation and you're trying to contract with the Department of Defense is going to get its ALCA involved to coordinate with OSHA to say, hey, OSHA, are these OSHA citations that you issued to company XYZ serious enough that it should impact whether we do business with them? And you think about this, the accuser, OSHA, is getting to decide and influence whether the government considers those serious enough to impact your contract award. The answer is always going to be yes, especially when one of the avenues that the ALCA and the contracting officer can take is to force you into a labor compliance agreement. And what this means is the ALCA and the agency contracting officer will go to you and say, well, we'd like to give you this contract, but we are concerned about your OSHA history. If you enter into this labor compliance agreement, we'll give you this $250 million contract. Well, that's a heck of a lot of leverage they're holding over your head to enter into this labor compliance agreement. And this is a brand new invention. What is a labor compliance agreement? What terms can the government require you to enter into? Well, the proposed rule doesn't say, and so we're left to guess what the government might do. Now, remember, Kate just walked through a list of failed rulemaking efforts by federal OSHA, things that OSHA strongly desired but could not accomplish through the rulemaking process. Well, I'm willing to bet good money that if you are trying to do business with the government and with the threat of a multi-million-dollar contract hanging over your head, they try and push you into an ALCA, I'll bet you that the terms that you start to see in these labor compliance agreements look like the graveyard of failed OSHA rulemakings. They're going to require you in your labor compliance agreement to implement an I-2P2 program, a rule that federal OSHA was not able to promulgate. If you are working with chemicals where there's chemical exposures, they're going to hold you to lower PELs than what they've been able to accomplish through their rulemaking. They might force third-party audits on you, an effort they've been trying to implement in the PSM and RMP context. Basically, OSHA's wish list, they'll be able to force on you with the leverage of a huge government contract. So to me, this is a rule that is not limited to the 2 slots that OSHA has at OMB. So it's got a good shot of becoming the law, and if it does, will have a major, major impact on everybody's ability to do government contracting. So I've rushed through that. If you have more questions about that, we've got a good article on our blog and I believe a recording up on our archive of past webinars about this rule that goes into more detail. So definitely check that out. I'm going to turn it over now to Dan to review some issues with the final rollout of OSHA's GHS HAZCOM standard, and then we will move on to the next 11 webinars in the series. I hope you can all join us for those. We'll make sure that those are shorter and we get you out of here in a reasonable amount of time. But one more topic here, turning it over to Dan.
Thanks, Eric, and hello, everyone. This is Dan Deacon speaking. This is actually my first presentation that I'm giving here at Conn Maciel Carey. I'm a rather new associate. I work in both the OSHA practice group and the labor and employment group. And I'm here to talk to you today about the final rollout of the GHS HAZCOM standard. So the HAZCOM standard has always been an important topic in the OSHA circles, and it's especially important in 2016 because the final rollout deadline is only a few months away, that being June 1st, 2016. As for 2015, it was one of the most cited standards. And of course, we received more guidance from OSHA with the release of its compliance directive in July 2015. So this is perhaps one of the biggest rulemaking, or if not the biggest rulemaking endeavors during the Obama administration. And there's certainly a lot to talk about. We plan on doing plan to do a presentation, a webinar on this on May 11th, 2016, Kate McMahon and I. So mark that on your calendars and be sure to tune in. But today I'm just going to give you a brief overview of the standard and some of the issues to look out for in 2016. So I'll start with a quick little background of the standard itself. It was originally published in 1983 and updated a few times since then, particularly in the mid-'80s, 1989, and once again in 1994. The purpose of the standard, of course, is to provide information to employers and employees exposed to hazardous chemicals in the workplace. The concept being, and what people have often referred to it as, is a right-to-know law. So initially, under the 1983 standard, it only applied to chemical manufacturers and importers, but again, it was revised in the mid-'80s and expanded and broadened the scope to apply to employers with chemicals generally in the workplace. But since, basically 1989, we were under the same standard until the revised 2012 version came out. But the HAZCOM standard, the original standard itself, was rooted in a 5-element program, 1 being the determination of chemical hazards in the workplace, 2, the development of written HAZCOM program, 3, labeling of hazardous chemicals, 4, the development of material safety data sheets, and 5, training of workers on hazards and precautions. And that is the same 5-element program that we have today in the current standard as well. So not much has changed to the actual format of the standard. So quickly, I'll touch base with you on the root of the revised standard, and that is the UN's globally harmonized system of the classification and labeling of chemicals. The idea of a global harmonization was actually echoed in the preamble to the 1983 standard. So this is an idea that's been a long time coming for OSHA, I guess you could say. The GHS was developed by the UN as a way to bring into agreement the chemical regulations and standards of different countries. In short, it's basically an international attempt to get everyone on the same page, the hope being that every country is going to incorporate the tenets of the GHS into their existing regulatory systems. So far, I think it's been 65 countries so far have incorporated the GHS, some of those provisions into their current regulatory structures. Keep in mind also that the GHS is not a law or regulation, rather it's a set of guidelines for countries to build off of. The countries can adopt whatever parts that they would like and ignore ones that they don't like, and each country is individually responsible for enforcing its own standards. It's also important to keep in mind that the GHS is a living document and that it's always changing based on science and technology, the updates to science and technology. So it's possible that OSHA will be revising the HAZCOM standard more often in the future. It's hard to say that that would be in 2016, considering a compliance directive was issued just less than a year ago, right? But this is something to look out for in the future. When the U.S. adopted the GHS, it was based on GHS Rev 3, and GHS Rev 6 was actually just issued in July 2015, and there's a couple changes to that I'll mention later. So with the adoption of the GHS standards, Dr. Michaels has now dubbed this revised standard, the 2012 standard, more of as a right to understand law, meaning not only will employees know about the potential hazards in the workplace, but also be better aware of what the warnings mean, what to do if you're exposed, and how to better protect yourself. So of course, the GHS brought a lot of changes to the standard itself, the 4 main ones being hazard classification, labels, safety data sheets, and training. So with the adoption of the new standard, OSHA anticipated that the revised standard is going to prevent 43 fatalities and 585 injuries annually, with a net annualized savings of about $500 million a year. They're also anticipating an increase in worker productivity. So if any of you have any, internal data to that effect, we would definitely like to know what's going on in your workplaces as you've implemented these changes. As for the revised HAZCOM standard itself, there's of course been some major changes, as I just mentioned, but the structure is largely the same. We have the same 5-element program that I just mentioned earlier, but we've shifted to more of a specification standard, that being, specifically how to classify and categorize classify chemicals. There's specific language and content that you need on SDSs and labels. So getting into the specifics, I won't address these too much because employers and employees should probably already be aware of the SDS requirements under the new standards. The deadline for compliance has passed, although there is deferral provisions, which I'm going to address later as well. But the SDSs are basically intended to provide comprehensive information about a substance or mixture for the use in workplace chemical management. It's a form of communication to downstream employers, just in a friendly user-friendly and consistent manner. So under the old standard, chemical manufacturers and importers were allowed to convey this information in whatever format they chose. There was a lot of discretion under the former standard. But under the revised standard, now there's a single set of harmonized criteria, and as you can see on this slide, there's 16 specific sections that you need to address, and that's to ensure consistency in the presentation of that important information. And also keep in mind that if the chemical manufacturer, importer, distributor, or employer preparing the SDS becomes aware of any significant information regarding the hazards of a chemical or ways to protect against those hazards, that information needs to be added to the SDS within 6 months. Again, I'll just touch base rather quickly on the labeling requirements, but this was another change under the revised standard. You can look to Appendix C in the revised standard here to get those specific requirements. But basically there's 6 of them. You need a common signal word, so that's something either like danger or warning, basically a word to indicate the relative seriousness of the hazard associated with that chemical. A pictogram, you can see on the slide here, there's 9 pictograms with a red border and a picture in the middle. You need a hazard statement. That's a brief, succinct description of the hazard, the nature of the hazard itself, for instance, fatal if swallowed or harmful if swallowed, something to that effect. A precautionary statement, that's the most lengthy word-wise of all the new requirements, and the appendix will actually direct you how to formulate that precautionary statement itself. You also need a product identifier. That's basically what the chemical is, and a supplier identifier. That's the name, address, and phone number of the supplier. As new hazard info is identified, manufacturers and importers have 6 months from the date of learning that new information to change the label. And the last part of the slide here I want to address is the alternative workplace labels. That is permissible under the revised standard, and that's one of the topics that needs to be updated by the June 1st, 2016 deadline. Employers they're allowed to use the alternative labeling systems in the workplace so long as the system complies with all of the 2012 HAZCOM labeling requirements by June 1st, 2016. So hazard classifications need to be revised as necessary to conform to the final rule, and other information provided needs to be revised accordingly to ensure that the appropriate message is conveyed. So the alternative labels, typically at a minimum, are only going to provide the product identifier and a general information regarding the hazards of a chemical. So the employer is going to need to make specific information regarding the physical and health hazards of that chemical available to employees through other means under its written hazard communication program and SDSs. So this slide is intended to give you a brief overview of the compliance deadlines. And in red here we have the June 1st, 2016 deadline approaching. I just went over the alternative workplace labels that need to be updated to conform to the 2012 standard. But again, just to highlight this is the final rollout of the HAZCOM standard, and the last deadline is approaching in less than 5 months or so. So if any of these are particularly important to your business and it's raising a red flag to you, that's something that you should certainly mark and address sooner rather than later. But the other 2 that I want to touch base on is the need to update and develop a written hazard communication program and provide additional employee training for newly identified physical or health hazards. So the written program itself is intended to ensure that the compliance with the standard is done in a systematic way and that all the elements are coordinated. So many employers, I'm sure a lot of you already have some form of a written hazard communication program, so this might be just a matter of tweaking it to conform to the 2012 standards. Just as a background, I guess, of what you need, a quick list of what you need in a written hazard communication program. You need 1, a description of the container labeling process. 2, a list of all the hazardous chemicals known to be present in the workplace. 3, a description of the SDSs and the process for preparing, obtaining, processing them, what to do when you receive them, what to do when you don't receive them. 4, the method by which employees are informed of the chemical hazards. and hazards associated with non-routine tasks like cleaning, and 5, the method by which employees can obtain the written program and an explanation of the training process. So that brings me to the last topic there, training, additional employee training for newly identified physical or health hazards. We'll just go over some of the training issues really quick. Again, so first, HAZCOM training needs to be provided at no cost to the employee, and employees actually need to be paid for that training. It needs to be provided in a language that employees understand, and this is very important. Training is not satisfied solely by giving an SDS to an employee. Okay, you need to explain the hazards of the chemical, how to access and use the information on the SDSs, and the labels. Chemical-specific training is not required. It can be hazard-based. However, chemical-specific information needs to be available to employees through SDSs. Just a final note on training, it's an ongoing duty. So training must be provided at A, the time of initial assignment, when an employee is initially assigned to a workplace, and whenever a new chemical hazard the employees have not previously been trained on is introduced into that work area. And the standard itself provides more detail on the training requirements themselves, such as the methods and observations that can be used to detect the presence or release of hazardous chemicals, and the protective measures employees can take to protect themselves. So I mentioned earlier that there were enforcement deferrals itself, and this can be particularly confusing for some people, so I'm going to do my best to get this information conveyed to you succinctly and not in a confusing way. So manufacturers and importers were supposed to comply with the labeling and SDS requirements by June 1st, 2015. But there is some leeway, that is, if they don't have the required information from upstream suppliers. So when that happens, they can defer compliance with the 2012 requirements. However, they need to show that they can't comply due to circumstances out of their control, and that they've exercised reasonable diligence and good faith in trying to comply with the 2012 standards. So in order to do that, you're going to need to provide documentation to show efforts to obtain info from the upstream supplier, 2, find hazard information from alternative sources, and 3, classify the data yourself, efforts to classify the data yourself. Under those circumstances, the manufacturer and importer is going to they're going to be allowed 6 months to create the SDS from the date that they receive the necessary HAZCOM info from the upstream supplier. And the same thing for labels. They're going to need to create new labels within 6 months from the date the SDS is developed. As for distributors, the distributors of chemicals, chemical mixtures, are permitted to use the 1994 compliant labels until December 1st, 2015. But because of the issues with manufacturers and importers that I just explained, possibly the inability to get the necessary information from upstream suppliers, distributors aren't going to be able to comply with the December 1st, 2015 label deadline. And of course, this has already passed. So actually, in an enforcement memo issued by Dorothy Doherty in February 2015, they actually extended this deadline to December 1st, 2017. So distributors have until December 1st, 2017 to actually comply with the 2012 labeling requirements. As for the SDSs, after receipt of a 2012 compliant SDS from a manufacturer and importer, the distributor's going to have to provide the 2012 compliant SDS to any downstream employer, downstream user with the first shipment or upon request. And as for employers generally, they can defer compliance with the 2012 labeling requirements and SDS requirements until the new SDS or label is received from the importer, manufacturer, or distributor. And that, again, is with a demonstration that they've made good faith efforts to obtain that information. So this is a quick slide on what's been happening recently in the HAZCOM context. OSHA has issued revised HAZCOM guidance documents over the past couple of years, one being the Small Entity Compliance Guide in 2014, the Compliance Directive in 2015. Of course, that's very important, instructing inspectors on how to properly inspect your workplace and enforce the new HAZCOM standards. So if you haven't read up on that, we definitely suggest that you do, because it's very important to understand how someone's going to be looking at your workplace. There's also been numerous interpretation letters focused mainly on exports, imports, and small packs, and we're going to cover those more in detail during the May 2016 presentation. And finally, I mentioned this earlier, the UN adopted the 6th revision edition of the GHS in 2015, so that could perhaps spark some changes. We'll see. And the final slide here is just a reminder that OSHA educates the industry with a heavy dose of enforcement. Year after year, HAZCOM's been one of the top 3 cited standards in OSHA's catalog, and that was even before they made the change in 2012. So in 2016, you just need to be paying very close attention to your HAZCOM program, especially with the final compliance deadline rolling out in 5 months. And, you know, who knows, this may have a shot at becoming number 1 at this point. And especially the later part of 2016 with those 3 issues that I discussed about the compliance deadline, those could definitely become a hot issue. So I'll turn this back over to Eric, and thank you very much.
All right. Thank you, everybody, for sticking with us. We were, only about 50% longer than we thought we would be, but we have finally come to the end of our presentation side of this. There are a handful of questions that were typed in here. I'll address a couple of those, but we appreciate everybody joining us today. This was a lot of fun for us, sort of logistically, getting our team together and just talking about, hey, what happened in the last year that was important and significant to us and our clients, and what do we expect is going to be important this next year. So we enjoyed talking about that together. We enjoyed talking about it with you, and hopefully you found this to be a valuable use of your time, a lot of your time, and I appreciate that. One thing I would tell you to do, if you found this information helpful, I'd also encourage you to check out our blog, the OSHA Defense Report, OSHADefenseReport.com. You can sign up in the top right corner of the page there, and that will push out to you automatically. It will send an email to you every time we put a new article up there, so check that out. And then if you're not signed up already for other events in the webinar series for the 2016 OSHA webinar series, do that or send an email to info@connmaciel.com, and we can help register you sort of automatically for the rest of the events in the series. So I am going to go back and flip through a couple of these questions. If we don't get to all of them, we'll try and get to them by email or something like that over time. There was a really important observation here that somebody made. We talked about how federal OSHA basically killed its efforts on the I-2P2 front. That's just federal OSHA, and that doesn't mean that state programs out there that do have an I-2P2 regulation, that they somehow lose their ability to enforce that because federal OSHA killed their proposed rule. California has an I-2P2 rule, still very much in effect, still very much the most frequently cited standard out there in California. I believe Oregon and Washington also have I-2P2 regulations. Other states may as well, and others are continuing through the rulemaking process. So that's something that, from a federal OSHA standpoint, that law is not happening, but the states do have that still in effect. Somebody asked for an example of the alternative workplace label concept. The idea there is that on sort of the non-traditional package of a chemical where it's received from a distributor or being shipped for downstream users, you might have a storage tank or a bin or a batch process in your workplace. So there's chemical within that container, and that's considered a container, but it's not a container that's going out into commerce. It's just for your use internally. You can use an alternative label on those containers. And an example of what an alternative label, acceptable alternative label might be, it might be the old 1994 compliant label or some other. It doesn't have to meet the special format of the new HCS 2012 with the specific pictograms. It just needs to convey the relevant hazards in any of a variety of different ways. The main question that we're getting is, will you all have access to a recording of this? or copies of the slides, and you will. We've recorded this, and I plan to circulate an email to all those who have registered, so you will automatically get that. We'll also, if you go to our blog periodically, you'll see that there is a post that has an archive of all the recordings, and there's also going to be sort of individual blog posts that says, hey, we did this webinar today, here's a recording of it. So with all of that said, thank you all very much. Happy New Year. Thanks for joining us today, and I hope you join us for other events the rest of the way here, and looking forward to visiting with you. And if you have any questions after today, you know, I'll speak only for myself. I won't insult my colleagues. I'm a huge OSHA nerd. I love talking about this stuff. Don't ever hesitate to reach out and ask questions by email or phone, and we'd be happy to talk about it. Okay, thanks everybody. Bye-bye.